In this video, we'll discuss the rights of minorities as provided under Article 29 and 30. So, the very protection provided to religious minorities also their rights to establish and administer educational institution and the state regulation and restrictions or states intervention and interference in these rights of minorities. And in that connection we would like to discuss the most important leading case, and that is the first one, Ahmedabad St. Xavier's College Society versus State of Gujarat. In 1974, Supreme Court pronounced that although commonly Article 29, Clause 1 is assumed to relate to minorities, its scope is not necessarily so confined as it is available to any section of citizens resident in the territory of India. This may well include the majorities, as pointed out in this leading case by the then Chief Justice Ajit Narayan Rai. And now we'll go to the second important leading case relating to rights of minorities, State of Madras versus Champakam Durai Ranjan in 1951, and it is one of the important leading cases where it was pronounced as regards Article 29, Clause 2, it should be read subject to Article 15, Clause 4, as inserted in the Amendment Act of 1951, permitting special provision for backward classes, thus overriding the earlier decisions. And now we'll go to the third important leading case relating to rights of religious minorities, that is Hindi Hit Rakshak Samiti versus Union of India in 1990. It was relating to regional language, where it was held by the Supreme Court that not holding an entrance examination, and that is pre-medical test in any particular language such as Hindi or any regional language does not violate Article 29 Clause 2. And now we'll go to the fourth important leading case relating to rights of minorities, that is Father Thomas Singhari versus State of Maharashtra in 2002. Supreme Court pronounced regarding the conditions as to admission fees. It is legal position is that the state cannot impose any restriction on the right of the minorities to administer educational institutions so long as such institutions are unaided by the state, except to the limited extent that regulation can be made for ensuring excellence in education, as it was pronounced in this important leading case, Father Thomas Singhari versus State of Maharashtra in 2002. And now we'll go to the fifth important leading case, that is Society for St. Joseph's College versus Union of India, in the same year, in 2002, it was pronounced that Article 31A requires a state, that is to say parliament, in case of a central legislature, or a state legislature in case of a state legislation, to make a specific law to provide for compulsory acquisition of the property of minority educational institutions, the provisions of which law should ensure that the amount payable to the such institution or the acquisition of its property will not be such as will in many manner impair the functioning of educational institutions. So now we'll go to the sixth most important case falling under rights of minorities, Revered Father W. Proust versus State of Bihar. In 1969, the Supreme Court exactly pronounced on conditions for aid or recognition as a condition of granting aid or recognition to an institution coming under Article 13, Clause 1, the state may impose reasonable regulations for the purpose of ensuring sanitation, competence of teachers, maintenance of discipline, and other things. So now we'll go to the next important leading case, and that is St. Xavier's College versus State of Gujarat. In 1974, the Supreme Court pronounced that the state cannot prescribe a condition that if an institution, including one entitled to the protection of Article 30, Clause 1, 6 to receive, stated it must submit to the condition that the state may take over the management of the institution or acquire it under certain conditions. Such a condition would completely destroy the right of the community to administer their institution. And now we'll go to the eighth important leading case, that is Frank Anthony Public School Employees Association versus Union of India. In 1987, as it was pronounced, there is no constitutional or other right for an institution to receive state recognition, and the state may impose reasonable conditions for receiving its recognition as to the qualifications or pay of teachers or qualifications of governing bodies, as it was pronounced in this important leading case, Frank Anthony Public School Employees Association versus Union of India. And now we'll go to the ninth important leading case, that is TM a Pai Foundation versus State of Karnataka. In 2013, Supreme Court pronounced the word minority is not defined in the Constitution, but literally it means a non-dominant group. It is a relative term and is referred to represent the smaller of two numbers sections or group called majority. In that sense, there may be political minority, religious minority, linguistic minority, etc. And now we'll go to the 10th important leading case falling under rights of minority, and that is Arya Samaj Education Trust Delhi versus Director of Education of the Delhi administration, and it was decided by the Delhi High Court in 1976, where it was expressed that backward classes on religion or language are not minorities within Article 30, as K. Munshi in the Constitutional Assembly debate pointed out. The Harijans, generally known as the scheduled caste, are neither a racial minority nor a linguistic minority. The Harijans are part and parcel of Hindu community, as it was decided in this important leading case, Arya Samaj Education Trust Delhi versus Director of Education of Delhi Administration in 1976 by the Delhi High Court. And now we'll analyze another important leading case, that is DAV College Trust and Management Society versus State of Maharashtra. In 2013, the Supreme Court expressed that the right conferred by Article 30 of the Constitution cannot be interpreted as if, irrespective of the persons who established the institution in the state, for the benefit of persons who are minority. Any person, be it non-minority in other place, can administer and run such institution, as it was declared in this important leading case by the Supreme Court. DAV College Trust and Management Society versus State of Maharashtra in the year 2013. And now we'll go to another important leading case, that is Secretary Kannur District Educational Association versus State of Kerala in 2010. The Supreme Court expressed that where applicant is a religious institution run by a minority which has a fundamental right to establish and administer educational institutions of its choice in view of the clear mandate of Article 30 of the Constitution. A writ cannot take a mechanical or straight-jacket approach in explaining the very provisions of Article 30 in relating to establishing and administering educational institutions by the minorities. And now we'll go to 13th important leading case, that is relating to St. Stephen's College versus University of Delhi in 1992, the Supreme Court expressed that right under Article 30, Clause 1 is subject to the regulatory power of the state. Article 30, Clause 1 is not a charter for maladministration, legislation for social welfare, and similar regulatory measures do not constitute an infringement of Article 30, Clause 1, so long as the minority is not deprived of the actual management of the institution. A law regulating certain matters concerning industrial relation, academic matters, and the like does not infringe Article 30, Clause 1. And now we'll go to another important leading case, and that is State of Kerala versus very revered Mother Provincial, and it was decided in 1970 by the Supreme Court in relating to the standards of education. So, the standard of education is not a part of management as such. As regarding minority institutions cannot be allowed to fall below the standards of excellency expected of educational institutions established and administered by the minorities, as it was pronounced by our Supreme Court in 1970 in relating to this leading case, State of Kerala versus very revered Mother Provincial. And now we'll go to the last important leading case that we have selected in regards to rights of minorities, that is St. John's Teacher Training Institute, Madurai versus State of Tamil Nadu in 1994. At what exactly Supreme Court delivered or pronounced that regarding requirements of regulation in order to consonant with Article 30, Clause 1, a regulation imposed by state upon a minority institution should satisfy the following requirements as it was laid down by our apex code in this important leading case, St. John's Teachers Training Institute, Madurai versus State of Tamil Nadu, where the very requirements were laid down by the apex code, or it must be reasonable. Those regulations of state, it must be reasonable, it must be regulative of the educational character of the institution, it must be conducive to making the institution an effective vehicle of education for the minority community or other persons who resort to it, and also it must not annihilate the institution as it was decided in this important leading case, St. John's Teacher Training Institute, Madurai versus State of Tamil Nadu in 1994 by our apex code. So here we completed up to Article 30 and exactly relating to freedom of religion rights of minorities. So, in our upcoming video, we would like to discuss all those raised questions that we have framed on law of property. So, we'll start from the question number 11 on law of property.